Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation. John Deaton, an attorney who advocates for XRP, has claimed that the United States Securities and Exchange Commission's SEC recent actions against the cryptocurrency industry are motivated by a desire to protect corporate capitalism rather than investors. Deaton emphasized what he perceives as an assault against cryptocurrencies, citing the SEC's activities directed at Coinbase and Ripple as examples. He said in his speech that his talk covered a wide range of topics, including the SEC's approach to cryptocurrency regulation and its stance on retail investors in the Ripple case, as well as the accredited investor requirements. Deaton, on X, Twitter, shares his firm stance that the United States is not a real capitalist system, but rather functions inside the framework of corporate capitalism. He uses the current economic climate and other factors to back up his claim. I've been stating for years that we don't live in a truly capitalism society, and I stand by that statement. In the United States, we have corporate capitalism. Take a look at how the requirements for accredited investors treat the middle class differently from the working class. Take a look at the assault on cryptocurrencies and on Coinbase, which welcomes unvetted users. ETIPS, PETS, Toja 30 Feast 30x 30. A retweet from John E. Deaton. Our John E. Deaton known, July 29, 2023. According to Deaton, the SEC has a wrong set of priorities if it directs its limited resources towards Section 5 prosecutions and focuses on the secondary market on exchanges rather than fighting fraud inside the crypto industry. He warns that if this strategy is adopted, it might discourage innovation and slow down the burgeoning Bitcoin business. Deaton also draws attention to the SEC's stance against individual investors, serving as friends of the court in the Ripple case. Deaton's position implies a lack of willingness to take into account retail investors' perspectives, lending credence to the idea that the regulatory body regulator may put the needs of huge financial institutions ahead of those of small investors. Related, Ripple predicts a $10 billion savings for financial institutions using blockchain technology by 2030. Concerns regarding a double standard in crypto legislation are brought up by Deaton. He said the SEC is wrong for not talking to forward-thinking organizations like Coinbase. Sam Bankman-Fried, the former CEO of the defunct EFS exchange, met with SEC Chairman Gary Gensler many times. The regulatory body's efficacy and impartiality, as well as the regulating body and the broader framework for digital assets, are called into question by the uneven differential treatment. The Securities and Exchange Commission's SEC inconsistent treatment of different market participants may slow the development of disruptive startups while benefiting more established organizations. The XRP community is still buzzing over the XL's 30 proposal, a long-standing movement aiming at bringing an automated market maker, to the XRP ledger XRP. Recently, Ripple's Key 2, David Schwartz, shared useful insights on the profit possibilities that traders and liquidity providers should anticipate with the deployment of XL's 30. Schwartz's remarks were in reaction to an extensive conversation on X, OK Twitter, started by XRP community member Lewis Jackson. Jackson attempted to describe the process of the future XRP Ambud, remarked that owing to various versions, he could not offer significant information on profitability. Schwartz noted an intriguing invariant on which traders may depend on the AM. However, he acknowledged that traders could depend on this invariant provided the AM's code was free of flaws. Remember that Schwartz already discussed how the AM's trading method works? When a trader adds two assets, such as XRP and USD, to a common pool for trading, they are rewarded with LPU liquidity provider tokens. The trader's contribution to the pool is represented by these tokens. The native XRP AM's architecture, according to Schwartz, assures that the trader may always redeem these ELF tokens for an amount of both assets that, when multiplied, equals the multiplied value of the assets they initially supplied to the liquidity pool. Schwartz provided an example to elaborate. He used a hypothetical scenario in which XRP trades for 50 cents per coin. In this example, he said that a trader may put 10 XRP, 50 cents each, and $5 to the liquidity pool in order to get LP tokens. Notably, when the trader redeems the LP tokens he acquired in order to reclaim his XRP in dollars, the product of the resultant XRP in dollars is always larger than or equal to 50. Furthermore, the algorithm behind this system is always working to improve the aggregate worth of the assets in the pool, guaranteeing that the product of their values never falls below a certain threshold. This assures that a trader will always be able to recoup at least the value of his contribution, if not more. While the XRP ledger AM definitely has enormous profit potential, there are still issues to address. As Jackson pointed out, predicting accurate AM returns remains difficult owing to variables such as market circumstances, trade volume, asset pairings, and fee structures. In addition, in response to Jackson's remarks, Molly Elmore expressed worry over temporary loss. When the value of deposited assets varies while in the liquidity pool, this occurrence may have an impact on liquidity providers. When engaging in the XLs, traders must be aware of this danger and consider their risk tolerance. In a recent development, SDI District Judge Jed Rakoff handed a serious blow to the decision in the XRP case. The judge's judgment authorizes the SEC to continue with its action against Terraform Labs and creator Do Kwon, strongly rejecting the difference drawn in the Ripple litigation between public and institutional sales. The court's verdict in Terraform Labs' lawsuit was made public by John Reed Stark, who shared it on Twitter. Stark, a former SEC attorney in the Enforcement Division, announced Judge Rakoff's decision on Terraform Labs' move to dismiss the SEC's action against them. Remember that Terraform Labs and Do Kwon's attorneys had requested the court to dismiss the SEC's complaint. The attorneys referenced the Ripple decision to argue that the assets in issue are not securities within the scope of the SEC. However, the SEC responded by arguing against adopting Judge Annalisa Torres's reasoning in the Ripple case and expressing its intention to appeal the verdict. In his decision, Judge Rakoff refused Terraform Labs' move to dismiss the SEC action, claiming that the SEC's jurisdiction and a reasonable argument that the Anchor Protocol, and Luna may have violated securities laws. In an impassioned remark, Judge Rakoff specifically disputed Judge Torres's judgment in the Ripple case, emphasizing his disagreement with the methodology employed in that judgment. He disputed the difference between public and institutional sales, which was explored in the Ripple case. According to him, the Howey test does not distinguish between consumers depending on the provenance of their coins, since all purchasers might fairly expect to benefit from the defendant's efforts. The judge's decision also called into question the Major Questions Doctrine, a Supreme Court decision that prohibits regulatory bodies from exceeding their jurisdiction. Some cryptocurrency defendants, notably Coinbase, have utilized the argument against the SEC. Judge Rakoff rejected this argument, finding that the Bitcoin business does not have the same vast economic and political significance as other regulated industries. To stress the gravity of this ruling, Stark said that Judge Jed Rakoff is considered as one of the most distinguished securities law jurists in the U.S. federal court system. The former SEC attorney also emphasized Rakoff's reputation for taking an unbiased approach. Ripple's L22, David Schwartz, voiced misgivings about the court's judgment, stating that it seemed to be based on the particular attributes of Terraform Labs' scheme rather than the generic characteristics of cryptocurrencies. Schwartz pointed out that the court's rejection of the Ripple case did not seem to be founded merely on a fundamental disagreement with its rationale. It is instead based on the factual distinctions between the two situations. He gave two interpretations of the court's decision. In one case, the court disagreed with the Ripple ruling because it applied additional factors not included in the Howey test. As a result, it suggests that the court may not apply or follow the Ripple rule in this instance. According to Schwartz, this is the worst-case scenario for Torres fans. The second reading is that the court rejected the idea that it should adopt the Ripple judgment in the Terraform Labs case because of idiosyncrasies in the Terraform Labs action, rather than because the Ripple decision directly implicates the Howey elements. Despite the unique circumstances of the Ripple case justified the difference between public and institutional transactions, the court considers that same factors may not be relevant in the Terraform Labs case. Schwartz emphasized that this would be the greatest argument for proponents of Torres' decision.